So you never made any verbal threats?
No.
You never threatened to harm this young man?
No, I did not.
Okay. Miss Evans-Lagway, I'm looking at a shattered window. What is this of?
This is of my Mitsubishi truck where she baseball batted my truck window.
Did that happen, ma'am?
It did not.
You've never damaged her property?
I have not, never.
Why are you suing for emotional distress?
Because I went to jail. I missed out on work. I continued to be harassed late at night, 1 and 2 in the morning, disturbing other tenants. I'm getting complaints about all of this behavior.
I'm not seeing any of that in your evidence list. I'm going to open it up.
I have a few questions before we excuse both of you.
Oh, and then I've got a few, too.
This relationship has deteriorated to this degree over parking spaces. Am I correct?
It's much more than that.
Well, no, I know it is. And there came a point in time when you revoked the parking privileges of the defendant. Am I correct?
In order for the tenant's car to be parked on the property, it must be currently registered and insured, and that information must be provided to me so that I am sure.
Was that in the lease?
Yes.
And after the parking violations, you claimed that the defendant still parked the car there and you had the car towed at least on 2 occasions. Am I
Correct.
No.
September 8th of 2021, I have a letter that you wrote to Stacey Evans, which was called a 3-day notice to quit, and you claimed that she was committing a nuisance.
Yes. The original case was dismissed.
Why?
Because Ms. Evans is on Section 8.
Yeah.
There are several protocols that have to be followed according to Housing and Urban Development, the federal government.
Right.
One of those regulations is that in the lease, it must say verbatim that the tenant has 10 days to respond to the notice to quit. My original notice to quit had all requirements besides that one sentence.
Is that why the eviction didn't occur?
No, it was rejected. She lost. A week after that, she refiled again another eviction notice.
And what happened there?
And that lost too.
Ms. Evans-Lagway, we have a number of emails from Ms. Bell at the end of 2021, so after you'd been there for about a year, where she writes to you about ongoing violations.
Right.
And you write to her basically profusely apologizing for your son's behavior.
Well, yeah, because she said to me that he cussed her out.
And you believed her.
Called her a bunch of names, and I said, I apologize for his behavior if that's what he did.
Well, you know, you didn't say if that's what he did. You said, I'm so sorry, he gets it from his father, et cetera, et cetera.
Okay, well, at that particular point, I was so desperate not to get kicked out.
Your son told us earlier that the pepper spray was a severe danger to your health
Yes,
because
it
of
is.
COPD.
Yes.
Then why are you carrying around pepper spray yourself?
I carried it around because she scared me because she sprayed me with it before I even started carrying pepper spray.
You understand that pepper spray has a very high probability of being used against you if you carry pepper spray.
Okay, well, I wasn't carrying it when I got sprayed by her.
But you were carrying it on September 28th, right?
No, it was in my house. I went in the house and pulled it out.
That's what I'm saying.
As well.
Why are you
As
using
her
pepper
spraying.
spray if it's a danger to your own
Because
health?
she was spraying at me with the pepper spray. So I backed up into the unit and grabbed my pepper spray, and she was still spraying my son with it.
Yeah.
All
And
right,
I
we're
sprayed
going to
her.
excuse the parties while we deliberate in this case. Thank you both very much.
This court is again in session.
Okay, Ms. Bell, Ms. Evans-Lagway, we have deliberated and reached a unanimous verdict. Look, you clearly caused each other a severe amount of distress during your landlord-tenant relationship. I think that was obvious to all of us. But we don't believe that any of it rises to the level of being able to come into court and sue for emotional distress. You both seem to give as good as you took at different times, and this was a horrible relationship that caused you both distress, but not in a way that is legally compensable. Which left us with the phone, Ms. Bell, and clearly there was an altercation. Clearly you were able to retrieve your phone and it was broken, but there were 7 different individuals there, and we didn't have proof that rises to the legal standard of what is responsible for the damage to your phone. So the judgment of the court is that the plaintiff's claim and the defendant's counterclaim are dismissed in their entirety.